Good afternoon, everyone, or maybe good morning if you're participating on the webinar. Welcome to today's Nonprofit Organizations Practice Group session on Grassroots Mobilization, what your organization needs to know. I'm George Constantine. I'm chair of the Nonprofit Organizations Practice Group, and I'm pleased to introduce a couple of great presenters who have a lot of knowledge on this topic that I think is of particular relevance given the timing where we are in the middle of an election year. Before I get to the introductions, though, just a quick pitch on the screen here is our next session, which will be in July 20th at 12:30 on fundraising issues, maximize your nonprofit's profile and fundraising efficiency. And it's always a popular program. It talks about the state and federal regulations that regulate nonprofit organizations' fundraising activities. So hope you can sign up for that. That one will be webinar only, no in-person part of that. So let me introduce our two panelists and speakers today. To my far left is Janice Ryan. Janice has been a partner here in the Venables political law practice for a number of years. She works very closely with nonprofit organizations as part of that work. And I think it's unfair to limit you to political law, Janice, because you do a lot of work with tax exempt issues, a lot of work on nonprofit governance issues and the like. And she has particular expertise and familiarity with this topic. She's a leader on both our nonprofit and political law practice groups. Next to Janice is Meredith McCoy, a counsel here at Venable, also working in the political law practice, also with tremendous experience working with nonprofit clients. There's a lot of intersection between the two issues that arise very regularly. And Meredith has been with us for a while before coming to join us. Meredith was an attorney at the Federal Election Commission. So we have some great experts here to talk about this topic. And with that, I will turn it over to Janice.
Thank you, George. Can you guys hear me? I don't think our mics are on before we get started.
Doesn't sound.
Is that on? Sorry for the technical delay.
Hello.
There we go.
All right. Can you all hear me now? Okay. We'll move it a little closer. Thank you, George, for that introduction. I'm going to go over the agenda today and introduce our presentation. I'm so glad that all of you could be here in person. For those of you who are joining online, welcome. We are going to talk today about the different kinds of grassroots communications and activities that all nonprofits want to use. You want to speak with the public, engage your supporters, get more supporters, engage your donors, get more donors. They are the types of things that you might do regardless of the type of nonprofit you might be, whether you are a public charity, tax exempt under 501c3, a social welfare organization, tax exempt under 501c4, trade association or business league, tax exempt under 501c6. It may vary according to the different kind of medium that you are going to be communicating under. Perhaps you're using mail, telephones, texting, social media, billboards. The different kinds of laws that apply may vary depending on the type of tax exempt organization you are. And we'll go over that a bit during this presentation. And the different types of laws that may apply may vary depending on the medium in which you're communicating. So we will give you an overview of the relevant laws and rules that you need to take into consideration when you are communicating with the public and your supporters. Probably each of the various areas of law, the topics that we will cover could be their very own webinar. So this will be a very high level legal overview. But then what we want to spend a good portion of today doing is walking you through some sample communications, helping you issue spot when our clients come to us with maybe they have a sample billboard or they have a sample social media post and they want us to look at it. They say, here's a communication. Is this okay? What do we do? What do we think about when we are vetting that kind of communication and trying to identify the kinds of legal risks that might come and legal consequences that might come from making that communication? So with that, Meredith, I will kick it over to you to help us identify the kinds of communications and interactions with the public that we might be talking about today.
Thank you. And is my mic on?
Yeah.
All right, great. So thank you all. Thank you for the introduction, George and Janice. Happy to be here. But we do understand that grassroots advocacy and grassroots engagement can mean different things to different organizations. And so we just wanted to start with a little bit of level setting about what we're including in that bucket today. And so to start, that includes list building, how you're cultivating your grassroots and how you're growing the tent and bringing more people into your support community. It may also include fundraising. This isn't typically what we think of when we think of grassroots engagement, but it really is engagement with your supporters. And so we'll talk about what to think about when you're asking your supporters for funding. Third, fourth, and fifth are sort of different types of engagement that we really view as a continuum because the lines between them are often hazy, but organizations often have strong thoughts about where they want to be on the continuum. And so we will talk today about education and issue advocacy, lobbying, attempts to influence actions by government officials, and then finally political campaigns, more electoral types of communications.
So Meredith identified list building. What do we mean by that? This is sort of any kinds of communications that you are sending out with the intent that you are going to collect names, addresses, emails, phone numbers, so that you can grow your list of supporters. You can send them more information, which hopefully will be, you can persuade them to support your organization, your mission, to change policy, to give you money, to further all of those things. And we think that this is an important concept to sort of set out at the outset, because at core, you are dealing with data, right? And we want to make sure that when you are thinking about your grassroots, you're thinking about your lists, that you are going to be making promises to those people at the time of collection about how you will use your data, or not making promises, but that you are actually going to be able to meet whatever you say in terms of your privacy policies about how you will use their data. Will you share their data? What rights do they have with respect to their data? And we also want to make sure that you are collecting the appropriate permissions from those individuals to continue to contact them in the future. And we'll talk about the legal reasons why that's important. Fundraising. What's important to know when you solicit money, really sort of in any form, whether you are sending emails, you have a donate page on your website or a donate button, you are making phone calls, it's important to know that fundraising for your charitable organizations, so public charities, 501c3s, and social welfare organizations, 501c4s, is regulated by most states, not all. There may be obligations when you ask for money to support your mission for you to register with the state and file reports with the state. Typically, it's annually, and that they want to know about who you are, and they want to know about your finances, and they want to provide a repository of information for members of the public to be able to look that up. It's kind of a consumer protection regulatory regime. Also consider when you are fundraising, what kind of activities are you fundraising for? There's one thing on this slide that I haven't mentioned, but that is important to know, is that if you are going to fundraise, solicit money from the public for a particular purpose, and you are a charitable organization, you need to be able to restrict that money and use it for that purpose. Under applicable state law, sort of the charitable trust doctrine and other kinds of rules of MIFA, the Uniform Prudent Management of Institutional Funds Act, which various states adopt, you have responsibilities to use funds in the way that you promised your donors you would use them. So that's an important thing to keep in mind. And then there's donor disclosure implications for raising money for particular lobbying or political activities. If you tell your supporters, please give me money, we want to work to elect certain candidates, or please give me money, we want to work to enact this particular piece of legislation. You should know that there may be obligations if you are a lobbyist, if you're required to register to lobby, or if you are required to file campaign finance reports, that you may need to disclose donors that have given money to you for those purposes.
So turning now to communicating your messages to your grassroots supporters and other types of grassroots engagement, the first step on that continuum is issue advocacy and educational outreach. This is particularly salient for 501c3s whose missions often focus on education, but it's also important for C4s and C6s and other types of organizations that might be doing issue advocacy campaigns, either because they have funds that are restricted to issue advocacy, or because they are sort of doing starting with a ground softening campaign or educating their constituents on an issue before they move into the take action portion of their campaign. And so it can be relevant to everybody. And so we will talk about that for all types of organizations. And it's important to understand, though, that because this is a spectrum, the line between issue advocacy and lobbying and the line between issue advocacy and political activity is not always crystal clear. And so, as you'll see when we move into the examples, we spend a lot of time about assessing where that line is and where the communication falls, on which side of the line that communication falls. And I guess on the last thing I'll say on that one is that just because you're engaged in issue advocacy doesn't mean it's not regulated. There are going to be laws around what your campaign needs to do to be compliant, even for issue advocacy. Moving on, we have lobbying communications, and these are communications that are an attempt to influence officials to take a particular type of action. And so, as we'll get into in a second, there are differences between direct and grassroots lobbying, and lobbying is itself regulated by a couple different laws, including the tax code, which sets limits on how much lobbying different types of organizations can do, and then both the federal as well as state and local laws that govern disclosures that are required as a result of engaging in lobbying. And we'll touch briefly as well on ballot measure campaigns, which are considered lobbying under the tax code. And not only are they considered lobbying, but they're considered direct lobbying, which really changes the nature of who may engage in ballot measure campaigns. But it also is important because some C3s that feel like they are not able to engage in campaigns and elections, this is actually an area that they can get involved in. So it's important to understand what sorts of disclosures are involved. And then finally, we'll talk a bit about political activity and communications that are intended to influence the nomination or election of a candidate for public office. And these there are both limits under the tax code on who can participate in political activity, as well as disclosure requirements set by federal, state, and local law.
All right, so we're going to get into the legal overview here. We previewed a little bit of that through the different kinds of communications that we've discussed. We're going to talk first about the tax law, the Internal Revenue Code. So as nonprofit tax exempt organizations, the tax code is going to govern what you can and can't say in many cases and maintain your tax exempt status. We're going to talk about campaign finance laws. We're going to talk about lobbying disclosure laws. Those are the big three. We're going to spend a little bit of time giving you an overview of various communications laws. Typically, those are going to be devoted to particular forms of media like email, telephone, TV, or radio. We'll talk about intellectual property and rights management in connection with your communications, false advertising and defamation considerations, and we'll talk briefly about postal rules. So to kick things off, we'll start with the tax code. The tax code regulates the extent to which 501c organizations may engage in lobbying and political activities. We'll have a little chart shortly that shows you what a 501c3 public charity could do versus what a 501c4 or C6 organization could do with respect to influencing legislation or influencing elections, specifically related to candidates. It also has rules around businesses, for-profit entities' ability to deduct payments that they might make in the form of, for example, association dues or membership organizations as ordinary and necessary business expenses. Dues payments that are for lobbying or political activities of an association are not deductible by those members. If you are an association or another membership organization that's a C4, you are required under the tax code to provide your members notice of the amount of non-deductible dues that they have. If you don't provide that notice, you're required to pay what's called a proxy tax. The rules around this are monitored by the IRS through annual disclosures in your Form 990. Schedule C has various sections for 501c3 organizations, C4 organizations, C6 organizations to disclose the kinds of lobbying and political activities that they engage in on an annual basis. We're going to start to talk about lobbying and campaign activity to provide just a few definitions for tax purposes. These are really rooted in the rules for 501c3 organizations that elect to measure their lobbying activity, these lobbying definitions under what's called the 501h rules. But they're just a basic general rule of thumb that I think is helpful to guide our conversation. The rules for C4s and C6s can be a little different, but I think for our purposes, let's stick with these. Lobbying is really kind of two different things. It's direct lobbying or grassroots lobbying. Direct lobbying is when you attempt to influence legislation through communications with covered officials. The covered officials are typically going to be the legislators, anybody who works for the legislature. It's not solely limited to that, but that is the primary source of covered officials. The other concept is grassroots lobbying, and that's really kind of where we want to focus today. Although direct lobbying is still important because, as Meredith mentioned earlier, ballot measure advocacy is direct lobbying under the tax code. Grassroots lobbying, the general concept there is that you are attempting to influence legislation through communications with the general public. I'm going to take a minute to talk about grassroots lobbying in a little bit more depth for 501c3 public charities that make the 501h election. The concept is that you may have a communication that expresses a point of view on specific legislation and includes a call to action. And some of the examples that we'll go through later, you'll see why this three-part definition is important. And I'm going to unpack it a little bit. We need to understand what specific legislation is, and we need to understand what a call to action is. Specific legislation is any kind of bill that's currently pending, that's been introduced in a legislature, absolutely qualifies, but it's not limited to that. It can be a specific legislative proposal that has not yet been introduced, but that you are advocating for, that you want to be introduced. A call to action is, there's a sort of a 5-part definition, 4-part definition, I can't remember. But there are very specific definitions in the tax code rules for what a call to action is. But for our purposes, it's asking people to contact legislators in some way. It could be explicit. Please call Senator Smith. You could be a little less explicit. Perhaps you provide contact information. You provide a postcard, a tear-off, or a link to an online program that allows people to directly email their legislators. that would be a call to action. Perhaps you simply identify that recipient's member of the legislature who will vote on the issue or specific legislation that you are advocating for. So we have a point of view on specific legislation and a call to action. That is grassroots lobbying for the tax code purposes. Campaign activity. For tax purposes, we sometimes call this political campaign intervention, but the idea is that you are attempting to support or oppose the election or defeat of a candidate for elective office at any level, federal, state, local. It's attempting to support or oppose a candidate. I guess before I move over to you, Meredith, I want to give a little bit more flavor of campaign intervention and how the IRS applies these rules. The IRS has given us some good guidance, and they use a facts and circumstances test, which again is sometimes challenging because it's sort of I know it when I see it. But in IRS Revenue Ruling 2007-41, they lay out a multi-factor weighing test. They say we're going to look at all of these various factors to determine whether a communication is issue advocacy, which is fine, or campaign intervention, which could be a problem. And what are those factors? Those are some of the things that we'll walk through when we go through some of our examples as well. Does the communication identify one or more candidates for a public office? The reference could be a picture, it could be a name. Does it express approval or disapproval for a candidate's positions or actions? Is it communicated close in time to an election? Does the communication itself refer to voting or an election? Is the issue that's addressed in the communication something that's been an issue that distinguishes the candidates in an office in a way that's sort of significant or high profile? Does the communication, is it part of a track record that the organization has of speaking on that issue without respect to the timing of a particular election? These are all the kinds of things that the IRS will weigh if they're trying to evaluate whether a particular communication is campaign intervention because it supports or opposes a candidate, or it is issue advocacy, which does not. So here's the chart that I previewed. If you are a 501c3 public charity, you are allowed to lobby. You can influence legislation. There are limits on how much you can do, however. You're not supposed to lobby in substantial part. If you are a public charity who chooses to measure your lobbying activities under 501h, there are specific dollar caps on how much you can spend on direct and grassroots lobbying. The grassroots cap is a subset of the overall total amount that you can spend on lobbying. It's 25% of what you can spend on total lobbying. 501c3 public charity may not support or oppose candidates. Political campaign intervention is prohibited. If you engage in that activity, the IRS could revoke your tax exempt status. 501c3s are typically subject to these restrictions, these limitations on activities for lobbying and political activity, partially because donors are eligible to take a deduction when they give contributions to public charities. That is not the case for C4s and C6s. Donors don't get a charitable tax deduction when they make contributions to those organizations. Those organizations can engage in unlimited amounts of lobbying, and they may engage in some activities to support or oppose candidates without losing their tax exemption. Those activities just cannot be the organization's primary activity.
So with that, I'll talk, I'm going to shift gears to lobbying disclosure laws, which are different from the limits imposed by the tax code and the disclosures required by the tax code. Both the federal government and state and local governments impose lobbying disclosure requirements. At the federal level, the law is known as the Lobbying Disclosure Act, or the LDA, which requires quarterly reports of lobbying activities by persons required to register. And Notably, the LDA does not regulate grassroots lobbying. If you are engaged in grassroots lobbying, it is not reported on that. It does not need to be reported on that report. But importantly, so I guess what the important takeaway there is that if you are engaged in grassroots lobbying for federal laws or for federal action by federal lawmakers, that's not going to be reportable. However, there are state and local lobbying disclosure laws that do cover grassroots lobbying. And so if you are engaged in a grassroots effort to influence state action or to influence local action, you should be aware of whether that jurisdiction has a grassroots lobbying law, which could require your organization or the individuals involved in the campaign to register and to disclose their activities. And typically those disclosures include the amount spent on the grassroots lobbying campaign, it may be, there may be other different types of disclosures. You may have to disclose the nature of your position, and the disclosure thresholds depend on the particular jurisdiction. Sometimes these laws are triggered, registration and reporting is required even before you ever make a public communication. In other locations, registration and reporting hinges on how much you spend or how much time you spend relative to your other activities. And so the takeaway here is that state and local grassroots lobbying laws are extremely fact specific. They don't exist everywhere. So before you go in with a campaign that would be considered grassroots lobbying, you should be aware of the legal landscape. And the last thing I'll say is that it's important to also understand how states define grassroots lobbying. The definitions range as well. And so some of them, Janice laid out what is a call to action under the tax code, but the state and local definitions do not necessarily align with the tax code. And so it's also important to understand whether what you're doing is lobbying for the state or municipality's purposes. And then, also under lobbying laws, I'll just add that some states do require particular disclaimers on lobbying communications. So in Texas, I think you have to, a lobbying ad would need to say legislative ad or lobbying ad and state who it is paid for on the face of the ad. So it's important as your content folks are designing the ads that they may need to be aware of particular wording on the face of those ads themselves. And those tend to vary with the types of media you're involved in. The disclaimer on a text message will be different from the disclaimer on a digital ad. That's just different from a disclaimer on a TV ad or printed piece of mail. So in addition to lobbying disclosure laws, we also have campaign finance laws. And like the lobbying laws, the campaign finance laws do not align perfectly with the tax code. So, and like the lobbying laws, there are different regulations at the federal, state, and local levels. So I'll speak briefly about the Federal Election Campaign Act, which is the federal law that applies to campaign finance disclosure. And this governs attempts to influence elections of candidates for federal office. So president and Congress. And really, it regulates speech that is, it only regulates certain types of speech. Basically, the courts over time have looked at this and said political speech is core First Amendment speech. And so there are only certain limitations that governments can place on political speech. And so really those limitations are confined to limits on contributions to candidates and parties and political committees, and then disclosure. And so these campaign finance laws, including the Federal Election Campaign Act, have evolved to specify what types of disclosure are required. But it's only required when you engage in certain types of speech. So really, this comes down to express advocacy and electioneering communications. Express advocacy is advocacy that expressly advocates the election or defeat of a clearly identified candidate. And what the Supreme Court has said is that express advocacy is use of so-called magic words the obvious ones you'd think of when you think of electoral advocacy: vote for, vote against, elect, defeat, send so-and-so to Congress. Words along those lines that clearly indicate you are trying to get someone to vote for or against a candidate. The candidate's slogan is considered a magic word. Anything that falls along those lines is going to be considered express advocacy. But it also covers a slightly broader group of, excuse me. It also covers other types of communications that are the functional equivalent of express advocacy. And what we mean by that are communications that are susceptible of no interpretation other than a call to vote for or vote against somebody. And so the FEC says that, without reference to the timing of the election, could a reasonable person look at this and view it as something other than asking me to vote for or vote against this candidate? And that is the test you'll see when we get into the examples that we apply when we're looking at whether a communication is issue advocacy or electoral. Can I read this and think something other than vote for, vote against this candidate? So that is generally the bucket we call express advocacy. The other bucket are electioneering communications. And these are really important for grassroots campaigns because electioneering, you can accidentally make an electioneering communication fairly easily. At the federal level, an electioneering communication is an ad that references a clearly identified candidate in the 30 days before a primary or 60 days before a general election and is broadcast by television or radio to the relevant electorate. So that's a very specific definition, but what it means is that you can have an ad that is clearly about a legislative issue, but if you are referencing a lawmaker who is up for re-election, you're referencing them by name, you're including their picture, you could have a reporting obligation because you have made an electioneering communication. At the federal level, this is limited to television and radio communications, so typically higher budget communications. But as I'll talk about in a second, state and local law does not necessarily limit it to those types of media. And so the bucket of electioneering communications can be a little bit bigger in some jurisdictions. So that's what the Federal Election Campaign Act regulates in a nutshell. States and localities also have their own campaign finance laws that govern communications that are with reference to candidates for state or local office. And because states engage in ballot measures, they also cover ballot measure advocacy. State regulations typically also cover express advocacy, and some, but not all, also cover electioneering communications. And these laws will vary in how they define express advocacy and electioneering communications. So again, as with lobbying, it's important to know as you go into a community whether what you're doing is considered political activity for the purpose of these disclosure laws. And I keep calling them disclosure laws, but it is important to recognize that in addition to the disclosure requirements, there are limits on contributions to candidates, parties, and other political committees. And the way this comes up often is if you are engaged in a public communications campaign and you are coordinating with some political entity, be it a candidate, a party, or a political committee, then you may be making what is known as an in-kind contribution. So if you are working on a legislative communication, but you're coordinating with the legislator who's up for re-election, this is something to think about. So not all jurisdictions prohibit corporate contributions to candidates, but the federal laws certainly do, and some states do as well. So it's something to be aware of when you are collaborating with candidates on your communications. And I'll also add that other things can be considered contributions, including use of corporate resources for fundraising. So if you are engaged in events with office holders, for example, where they might want to raise money, allowing them to use your space, your staff, your branding can all trip campaign finance laws. So that's something to be aware of as well. So that's contributions in a nutshell, but then we come back to disclosure as well. And the only thing I'll add here is that oftentimes these disclosures are time sensitive. So at the federal level, if you make an independent expenditure or an electioneering communication, those communications may need to be reported in as little as 24 hours after the communication is publicly disseminated. So if you might be engaged in a communication that is covered by these laws, you need to be on top of your disclosure obligations, because if as little as a day passes and you haven't made that disclosure, you may be facing some fines. A couple other things that we won't spend a lot of time on, but want to float across your radar screen is that corporations, nonprofit organizations can trigger registration as a political committee, particularly at the state or local level. If you are advocating for a ballot measure, you might have to register as a ballot measure committee. Or if you're under certain other limited circumstances, you may be required to register and report as a political committee. And once you're considered a political committee, that typically involves a more robust type of disclosure rather than sort of a communication specific disclosure. As we've alluded to, disclaimers are often required on various types of communications. Campaign finance laws often specify both the wording and the format of these disclaimers. Also important to be aware of is that even if you are not making public communications, but you have a partner that you are giving money to that is making these disclaimers, in certain states, they may be required to list their top donors on the face of their ads. So this is very big in the Pacific Northwest, where they may be required to list their top 5 donors or their top 3 donors on the face of the ad. So if you are heavily funding a campaign, this is something to be aware of if you are sensitive to disclosure. Events with office holders, there are very specific rules around events with office holders, depending on the format of the event. If it may reference the office holder's reelection, that may be covered by a campaign law. There are certainly ways to do events with office holders in an election year, and that's something we spend a lot of time with our clients on, is how to do these events without tripping up triggering campaign finance laws. But it is something to keep on your radar screen if you're planning an event with lawmakers in an election year. And then finally, something we like to throw out there, because data is king these days, the FEC has a robust trove of data that is all publicly available and can be downloaded from their website. But it's important for organizations to know that as tempting as this trove of data may be, the FEC has very clear rules about how FEC data may be used, and in particular prohibits the use of FEC data for fundraising purposes. And this is basically a consumer protection mechanism, such that they don't want people to feel penalized by contributing to candidates or other political committees by then having, every used car salesman pulling that data and hitting them up for money. So, I think as you're looking for new and interesting and useful sources of data, just be careful around the FEC data, as tempting as it may be.
I will add, before we head to communications laws, that state voter file laws are also something to consider with respect to this last point that Meredith made. Many times you all may think that the voter files at the various state levels are really useful sources of potential folks that you want to communicate with, because you want them to vote in a particular election, for example. You can, in many cases, do all of that. But the state voter files can, in some cases, have limits on how you can use that personal information, name, address, email address. You may find that some of the states prohibit the use of that information for commercial purposes, so to sell goods or services. And some of the laws will say you can only use it for political purposes, and they define political purposes in various specific ways. Lobbying might be okay in some states. In other states, it might be that you could only use that data to talk about elections. So that's another source of regulation that you might want to keep in mind. I'm going to talk briefly about these areas of law, which are really, we're going to lump under communications laws and industry requirements. So some of these aren't laws per se, but they are rules that you will find as a business matter are a practical matter going to be really important to how you communicate with your supporters. Canned spam, this is a federal law that applies to email. It applies to commercial email. So if you are going to send email that markets or sells goods or services, even if you are a nonprofit, you need to know about canned spam. There are prohibitions against, having these emails be false or misleading. There are specific requirements for identifying it as advertising. You need to include the name and a postal address of your organization in the body of the email, and you need to provide an opt-out option for the recipients. The TCPA, the Telephone Consumer Protection Act, this applies to telephone calls. There's really kind of two major categories that we'll talk about. There is the do not call registry. There are rules around restrictions in terms of timing of when you can place calls, before certain hours, after certain hours, off limits. And then there are rules about identifying yourself in the call as the sponsor of the call. Most of these rules, it's really in the second bullet here, do not apply to nonprofits, but as a matter of best practice, we recommend that our nonprofit clients follow those rules. You don't want to pester your supporters by calling them at 6 o'clock in the morning or 10 o'clock at night. They're not likely to be happy with you if you do that. The other category of regulation under the TCPA is about calls placed using an auto dialer. This has recently changed because of a decision by the Supreme Court, I guess early last year. It's the Facebook case in which the Supreme Court really, I think, narrowed the definition of auto dialer to such an extent that we're not really sure that most modern technology that our nonprofit organizations are using even qualifies anymore. But the concept here is about requiring express consent before you send a call or a text message to one of your supporters on a cell phone, or before you make a robocall. So a message, a voice message, an automated voice message. That's what the TCPA is meant to require. I'm going to jump to this bottom bullet, which I think is going to sort of be the most practical thing that you need to consider right now, rather than TCPA liability, is that the wireless industry has guidelines for sending text messages. And the wireless carriers have started requiring nonprofits, businesses have been doing this for a little bit longer, to register under what they call their application to peer, 10 DLC is 10-digit long code, systems. And this is about essentially ways for the wireless industry to protect consumers from unwanted text messages. The nonprofit community, many of our clients have had really, I think, a great experience with text messaging, peer-to-peer text messaging. So, there are campaigns that you might want to engage in which you have a script and you have a lot of volunteers, and each one of those volunteers agrees to make a number of text messages to the list to get them to do something. Maybe you want them to turn out at an event, a rally. Maybe you want them to contact their member of their legislature to support a bill. Maybe it's about electing a candidate. In the past, we've thought this is peer-to-peer. I don't need prior express consent. This is, one person texting another person. This isn't an auto dialer. I don't need to have consent before I make that text message. These rules, the wireless industry guidelines and the A2P 10 DLC requirements basically say no. You have a script, you have a platform, your members are all sending the same kind of message. This is application to peer, and we're regulating that. If you don't register and you don't follow our rules, they're going to throttle your messages. They're not going to get through. I think that the rollout of this is probably gradual. I know some of our clients have experienced it. Some of you may have yet to do so. But the core takeaway that here is that you need opt-in before you text message. So you need your supporters to have agreed that you can text them. And that will come back. We'll talk about how you do that and sort of the importance of that in a little bit. The last thing I'll touch on, well, two things actually. The first is the Federal Communications Act. This applies to broadcasters, so TV, radio, satellite. If you are placing advertising with broadcasters, you have to include a paid for by on your ad. It's a requirement. Sometimes clients ask about, well, what can the name be? It needs to be your legal name. It can be, let's say you have a brand that you're operating under that's not your legal or your name, your organization's legal name. You could register the brand as a doing business as with a state or other kind of jurisdiction. And in that case, it's typically fine for you to use that registered DBA in the paid for by line. But you will need a paid for by on any television advertising, whether it's issue advocacy, lobbying, campaign finance. The source of that requirement is the Federal Communications Act. It's not any particular lobbying or campaign finance rule. The last thing I'll touch on, it's not listed here, but you're all engaged in digital advertising. All of the various platforms in which you might place digital ads are going to have their own rules about, the verification of the identity of an ad sponsor before you start placing ads, and disclaimer rules that must appear either in connection with your account or on the face of the various ads.
So we're running down on time, and I do want to make sure we get to the examples, so we'll move through this pretty quickly. But I wanted to talk briefly about intellectual property rights management. As you're engaged in grassroots campaigns, make sure that the content you're producing is content to which you have rights. Do you own the content? Is it content you've licensed? And if neither of those is true, make sure that you have a good fair use case, and that you are comfortable that, should the owner of that content raise questions as to why you've used it without permission, you feel like you have a sound legal basis for having done so.
Yeah, and then we'll talk about the importance of truthful advertising, truthful communications. Some of this is a legal consideration, but it's absolutely reputational as well. Talk a little bit about astroturfing. So, if you were to create a grassroots campaign, you want to generate letters to members of Congress. If you make those letters up, if they are false, those people have not actually, maybe the people don't exist, and or they've not been the ones to send the letter, that's going to be a problem. It's not good for your advocacy work and your reputation. No one is going to trust you. The broadcasters have obligations not to air false and misleading ads on their TV and radio stations. If you have an issue ad, and someone complains that something in your ad is not truthful, they may send a takedown letter to the station. And when the station gets that takedown letter, they're going to come to you and say, can you substantiate that these statements are true? And if you can't, they may take your ad down, and you therefore have lost the value of all the thousands of dollars you've paid to produce a beautiful television or radio advertisement, and that would be unfortunate. And then moving into defamation, if you are saying something false about an individual or perhaps a business, and you are negligent or reckless with respect to whether that was true or false, and that causes harm, that statement causes harm to someone, you could be subject to liability for defamation. Lastly, postal rates. If you are a 501c3 or maybe a 501c4 that has a nonprofit postal permit, you may be able to get discounted rates on your mailings. There are rules, though, about what can be in those mailings, what you can send under the rates. There are also rules and restrictions against sharing your postal permit. So you need to be very thoughtful about, if you're doing direct mail, what are you including in that mail, and who is the mail really on behalf of? All right. let's dive into some of this. We'll start with this list building thing. I know it's a little hard to see, but I did want to show this picture and, highlight a couple things. There's a lot of forms. Give me your email address, your name, your phone number, your zip code. But underneath that, it says, there are these two little check boxes. They're empty right now, radio buttons. It says, send me text messages, or I can't read it from here.
Like someone to contact me about volunteer opportunities.
Right. And so before someone, goes through, if they hit that button, send me text message alerts, that is your first point of opt-in. Some clients say, can I pre-check that box? Okay, sure. But if you're thinking about it, you need to probably make that bigger, right? You don't want somebody to just sort of fly by the button where it says, I have opted into text messages. Because what if they didn't see it and you send them a text message and then they say, I don't want this. Why did you do this? Why did you send this to me? That's not great, because then you are wasting your money texting people who don't want your messages. But also, you want to make sure that you have good proof that you have consent. Below the join button is some other legalese, which again, my eyes aren't working, but essentially what it says is that you are going to disclose to them how they can opt out. Text stop to opt out. That message and data rates may apply. So most of us now have sort of unlimited texting plans, but some people still pay per message. And so you want to disclose that to people up front. You want to say something about message frequency and who's going to send the text messages. Are they going to get a text every day? Is it 3 times a year? So these are the kinds of disclosures that you want to provide to people at the outset. One thing that I have here is that we recommend that you have double opt-in. So what is a double opt-in? So this person says, I check the box, send me text messages, and you will send them an automated text message that says, great, so glad you joined us. Please type yes to subscribe. Or, it's a confirmation. And so then they will take another action. They will type yes or Y or something. And then you have confirmation that they didn't blow by that. They do really mean to sign up to your list and that they are consenting to get text messages from you. So that's what double opt-in is. The one thing that I talked about earlier is the privacy policy. So typically you're going to reference in these terms, these tiny little terms, that your privacy policy applies. And your privacy policy is the place where you tell people what you're going to do with their data. So are you going to share it? Are you going to sell it? If you are going to potentially engage in list swaps with other organizations, or there are some sort of broker arrangements where you might get money for your list, if your privacy policy says you won't do that, you should not do that. So make sure that your privacy policy covers all the kinds of things that you actually want to do with people's data, and that identifies, again, what they can expect in terms of how you will use it and how you won't use it, and how they can maybe ask you not to use it anymore. There's lots to say about that, but I want to get into these.
So from here on out, we're going to take you through a few sample campaigns with credit to our colleague, Ron Jacobs, who uses Save the Starfish as a recurring theme here at the Venable Political Law Group. So against that backdrop, we'll start with this first example.
Yeah, so I guess, I don't know if I'll call this Socratic method, but I'm going to tee up some problems for Meredith to answer. So I'll read out a sample communication here. And Meredith, I hope you will advise us on whether this is issue advocacy or general education or something else. All right, starfish are essential to the marine ecosystem. The U.S. must take steps to protect vital habitats. Learn more by clicking here.
So I think this is very quintessentially issue advocacy It's talking about an issue. There is no reference to particular legislation or even a particular policy proposal. It's really, what does taking steps mean? It's vague enough that we are squarely in issue advocacy territory. And it also, the call to action here is to learn more. So it doesn't appear to be asking the public to contact a lawmaker or enabling them to do so.
Okay, so it's not lobbying for tax purposes. Lobbying disclosure?
Probably not. Again, not likely to trip most federal, state, or local laws because we're not clearly discussing a piece of legislation or a clear official action.
What if we make a slight tweak? And instead of saying the US must take steps to protect vital habitats, we're going to say the US must fund federal programs that would educate communities about the value of marine ecosystems and impose fines against violators.
So I think this is a bit of a trick question. While this example is giving it is discussing a more specific policy proposal, and inherently funding programs tends to be a legislative function or perhaps a regulatory function if the funds have already been appropriated. But you know, because we are talking about federal legislation here, it's not grassroots lobbying because the Federal Lobbying Disclosure Act does not regulate grassroots lobbying. And it's also not going to be lobbying under the tax code unless we are changing our call to action here.
All right, you ready for a new one?
I'm ready.
Okay. Starfish are essential to the marine ecosystem. The legislature must fund state programs that would enforce habitat protections and impose taxes on polluters. Get involved by clicking here.
So this one, we are now, it's similar to the federal example. It is sort of discussing a more concrete legislative proposal. We're talking about funding state programs to do a specific thing. I think we would generally treat this as certainly much closer to specific legislation or legislative proposal if this is an issue being discussed in the state where this communication is going to be disseminated. So we check that box, and we're clearly taking a position on the issue because we're saying what we want the legislature to do. I think what this hinges on whether it's going to be lobbying under the tax code and under state disclosure laws is this call to action. What does it mean to be clicking here to get involved? What does getting involved mean? What happens when I click there? So we're not so specific that we're saying, call Senator Smith, but what if when I click here, it generates an email for me to just hit send on to my lawmaker? Then we are enabling the recipient to directly contact their lawmaker. And I think we're much closer to lobbying under both the tax code and if it's depending on what the state law or the local law says, we could be required to disclose this to that regulator as well. So I think here we are much closer to lobbying than we were on the last slide.
Right. Okay. So probably lobbying under the tax code, but it depends on that call to action. That's the sort of, okay, well, it's not a CTA directly in this communication, but the landing page includes a CTA. Do we sort of have that thread where we look at it as one communication? Some people may be comfortable separating them. The IRS probably would think that when you click here and the call to action is on the landing page, that this looks like a lobbying communication.
But it's a good point to make that for organizations that want to be on one side of the line or the other, there are these slight tweaks that we can make to things like how we describe the legislation or issue, or what call to action we include to put you on the side of the line you want to be on.
All right, we're almost out of time here. So let's see. Do we want to move through?
Let's move to, this next one is very clearly, I think, lobbying. We have a clear call to action. So maybe we move to the next one.
Okay. The one comment about this particular one is that it references an elected official. This is clearly a lobbying ad. You're trying to encourage a senator to vote on specific legislation. But if this is issued close in time to an election under the federal Campaign Finance Act, this could be an electioneering communication and could trigger an electioneering communication report that you have to file with the FEC.
So Janice, this one reads, starfish are essential to the marine ecosystem, but Senator Smith doesn't care about our planet. All he cares about is collecting campaign donations from the wealthy corporations that pollute our oceans. Tell Senator Smith to put constituents first. Much more typical of the types of C4, C6 communications we often see. Where does it land on the spectrum?
Yeah, so nonprofits like to do accountability. What does that mean? Well, it could be legislative accountability, but this is sort of a gray area and it can very easily slide into election influencing activity. These are very personal critiques. They're not necessarily focused on the legislation that might be related to the marine ecosystem that this organization supports. There isn't really a lot of mention of that, in fact. So, nonprofits, including 501c3s, can do what we call thank and spank ads, where you want to hold your member of Congress or other legislator accountable for supporting the issues in their, elected official role that your organization cares about. And if they don't vote the way you like, many C3s do want to send information out to their supporters and to the public to say, Senator Smith didn't vote for this. But this kind of framing can very easily be viewed as election influencing, particularly under all those guidelines that I read out to you, the multi-factor test that the IRS uses. If it's close in time to an election, if there's any mention of voting or elections, it gets riskier. So, there are ways to do this kind of accountability work that is not going to be campaign intervention, but you have to be really careful about it.
So this one continues the accountability theme, and I think is something we see a lot of in election year.
Yeah, so this is a voting record. Meredith, can you talk a little bit about, under the tax law, is this campaign intervention?
So this one probably is, but I will say at the outset, there's a way to do this that would not be. Here, the key things to focus on is there are clear references to the election. It says election day is coming, know your candidates. It does not say know your lawmakers. And the way it has, while it has teed up a few issues that appear to be important to the organization, it has also clearly expressed what the organization seems to think is the right answer to these questions. So the green check marks, the red X's are clearly showing how the organization feels these candidates should have answered. And so under the tax code, I think the IRS is likely to view this as campaign intervention, but there is a way to do it that is not. So you can do legislative scorecards as a C3, but they need to be clearly nonpartisan, and you can't put your thumb on the scale. They should also be clearly legislative. And so you're going to want to do them with respect to perhaps a whole delegation of lawmakers relevant to this constituency. You're going to want to cover a broad range of topics, and you can't indicate either through the way you have framed the issues or other implicit cues that there is a right answer to these issues. You are educating your recipients as to where their lawmakers stand. You are not indicating who they should support as a result of those actions.
What about express advocacy under campaign finance laws? Does this expressly advocate the election or defeat of Smith or Jones?
So it doesn't use magic words. It doesn't say vote for Jones. It doesn't say vote against Smith. But again, for similar reasons, it is putting its thumb on the scale. And could a reasonable person look at this and say, oh, I think it wants me to vote for Smith? Or is somebody going to look at this and say, the only thing they could possibly be asking me is Jones? And this is a question that it gets very interesting for us because we all come to these communications with our own biases, and we know as lawyers and as members of organizations, what we think this organization is trying to say. But it's important for the campaign finance laws to look at this objectively and say, could somebody read this and think, they want me to vote for either one of the candidates. I think here they are putting their thumb on the scale still. For me, the check mark, there are clear electoral references. And while, Smith isn't a red X on every single issue, there is clearly an imbalance between the two, and the check marks and the red X's really sort of convey the right or wrong position. So this next one is about ballot measure advocacy.
Next to last, for
Next
those
to
of you
last,
waiting for
yes.
at home, I know, we're very close to the end.
So this last one, the second to last one is ballot measure activity, and the campaign reads, "It's been a long few years. Americans need a vacation, and with inflation on the rise, we can't afford increased costs on our summer break plans. Tell the legislature to stop taxing your vacation. Vote no on Prop A." So Janice, could this be a C3 communication?
Yes, this is direct lobbying under the tax code, and a public charity can lobby within limits. So if you have room within your lobbying expenditure cap to do this activity, this is direct lobbying, so it's not the lower grassroots limit. You could pay for this ad.
And then what campaign finance obligations might there be, though?
So this is the funny thing about ballot measures. They're lobbying for tax purposes, but they are also governed by campaign finance laws, because these are matters that are voted on by the citizens at elections. This is expressly advocating for the ballot against the ballot measure. And under state campaign finance law, this could be an independent expenditure, which would require filing campaign finance reports disclosing the amount you spent on this ad. And if it's done in coordination with a ballot committee, it could be a contribution to that ballot committee. C3s and others should also keep in mind that sometimes any amount spent or amounts spent above specific thresholds on ballot measure advocacy could trigger political committee reporting requirements for the organization. And as Meredith mentioned before, when you become a political committee, you have a broader range of reporting requirements. Basically, you disclose all amounts in all your contributions and everything you spend. So typically, organizations that want to do ballot measure activity should also think ahead of time. Maybe I should set up a separate PAC so that I can do this activity. I can make contributions to the PAC. Other people can make contributions to the PAC. We can fundraise from others to do this activity without disclosing our donors. And last but not least.
All right, so what do we have here? This is quintessential endorsement. Not okay for C3s out there, but very typical for C4s and C6s. And so the question I think on this one is, to what extent are the campaign finance laws triggered?
I'm going to ask you, Meredith, actually, because I've teed this up for you. Can I put this in a press release? It says, we're proud to endorse these candidates. These are federal candidates, and remember to vote on November 8th. Can I issue this as part of a press release?
Yes.
Under federal law, federal campaign finance law.
Under federal law, an organization can put out their endorsements through their typical channels and announce to the public and to their supporters who they've endorsed. The rule is that it does need to be through your typical channels. So if you normally send out a press release, you normally put it on your website, those are all going to be part and parcel with your usual activities. And so you can send out your endorsements that way. Right. Not reportable.
Is it okay if I put it on my website?
So website, again, because it's a typical channel, you can do that as well. And, again, not going to trigger a campaign finance report.
Yeah, federal campaign finance law has something called the internet exemption. We don't have time to talk about that, but the website is going to be okay. What about my social media feed?
Social media. So here we get into some interesting questions about social media and how you're pushing it out. Your organic social media channels, so your unpaid social media channels, your organization's own Facebook page, a link on your Twitter or your Instagram, those are all fine. And again, are going to fall into the internet exemption that Janice referenced because they are unpaid internet activity. But if you start to promote your posts, then we start to get into a world of paid advertising. Even though it is social media, it is considered paid advertising because you're paying to push it out to a new audience. And so that is not within the internet exemption. And it could trigger campaign finance reports if you are spending a certain amount on it. So there's a fine line to walk between organic social media and paid social media.
Can I send it in an email to my members?
Member communications. So at the federal level, again, there is a carve out for membership communications. If there is a very particular definition of member, so it's not sufficient to say, you know, everybody who receives our emails is a member. Not quite. There does need to be a closer attachment, typically either by paying annual dues and affirming your membership or having some sort of governance stake in the organization. But if you maintain a list of folks who do meet those criteria, you can push emails out to that list containing express advocacy, and it will not trigger campaign finance reporting.
Last but not least, what happens if I communicate with the listed candidates about this communication?
So communicating with the candidates, if it is not covered by one of the exemptions that we've talked about, the free internet or a membership communication, then we get into territory where your communication costs may be considered a contribution to that candidate. So what the federal rules say is that it's fine to engage with candidates for the limited purpose of gathering information needed to make endorsements. So you can send them your questionnaire, they can fill it out. But what you don't want to do is start to coordinate the strategy or means by which you push out your endorsement. So if you start talking about to a candidate about, hey, it'd be really great if you could push this towards folks in a particular city or to a particular demographic, that's going to that will be considered coordination. And if the communication doesn't fall within an exemption, it's going to be a prohibited contribution to that candidate. So draw the line at obtaining information for your endorsements, but not communicating about how communicating with candidates about how those endorsements are pushed out to the public.
Thank you.
That's what we got.
Thank you everyone for sticking with us. Sorry we went over time. If you have questions, please, I know that our team is monitoring the chat. We will try to get back to all your questions. And thank you again for joining us.